Becoming an informed voter is the best way to protect our democracy. Now I'd like to introduce our moderator, Jim Masters, a board member of the League of Women Voters, who will introduce the speakers.
Thank you, President Roper. And you viewers have probably noticed that there are some challenges with her internet connection and her microphone cutting in and out. First, I'm going to introduce District Attorney Ravage and then Chief Deputy Public Defender Slater. And then each will speak for up to 15 minutes, maybe 10 to 15 minutes each. And then we have some prepared questions from the board members of the League, and you can submit additional questions. We'll try to take your questions first. The way the questions work is that they go in through the email to the League of Women Voters website, where Leona Judson screens the questions, consolidates them if there are several on the same subject, and then emails them to me, and then I read them to the speakers. So it's a kind of a loop there that we have put together. So I'll start with District Attorney Jill Ravage, a UC Berkeley grad, a USF Law School grad, been practicing criminal law for 35 years in various capacities. In 2012, she was elected District Attorney of Sonoma County, the first woman elected as District Attorney in Sonoma. She's finishing her third term and will be retiring at the end of the year. She opened the Family Justice Center in 2011, which helps victims of crimes and domestic violence. She established a dedicated elder protection unit. She is an adjunct professor at the Empire College Law School. Chief Deputy Public Defender, that's kind of a long title, Lynn Stark Slater, has been with the Sonoma County Public Defender's Office since 1990. She started as a law clerk and is currently one of 2 chief deputies, where she supervises and trains other attorneys and manages a caseload focused on those with substance abuse disorders and major mental health challenges. Since 1997, she's been a professor of law at Empire College. She's a frequent presenter to the Sonoma County Bar Association on mental health law and the California Public Defenders Association on law practice management. She's also on the board of the Sonoma County Women in Law and co-chairs their events committee, including upcoming forums for judicial and sheriff candidates. She's an exceedingly proud Santa Rosa native and is enjoying a relatively new empty nest. And before District Attorney Ravage presents her remarks, we need to ask Ms. Slater, what is a relatively new empty nest?
We were empty nesters for all of about 6 weeks, having launched the kid off to the Midwest to a university when the nest burned down in the Tubbs fire.
Oh,
Wow.
So we rebuilt the nest, and the child has relaunched back with a bachelor's degree and a new job.
excellent. So you had an empty nest and then it burned down and you have a new empty nest. That's sort of
Correct.
I see. I understand now. Thank you very much. We'll begin with District Attorney Ravage making her opening remarks.
Great. Thank you very much, Jim. And thank you to the League of Women Voters for inviting me to come and join you at this forum. I have been with you on prior occasions as a candidate, so it's nice to be with you as a soon-to-be retiree. I can say that it's been a pleasure working with Lynn Slater for the last 30 years in different capacities, because I think that underscores hopefully the tone of what you'll hear tonight, which is that the District Attorney's Office and the Public Defender's Office strive to work together, even though we have different clients whose interests we represent in court. The District Attorney's Office is charged with reviewing and prosecuting all crimes that occur in Sonoma County. We assist our law enforcement partners in their investigative efforts to determine if indeed crimes have occurred and whether or not individuals are responsible. We may be called out to a scene. We have a team available 24/7 to go out to homicides and suspicious death crime scenes. We also review every search warrant that is executed in Sonoma County before it's presented to a judge. We'll get calls on all kinds of questions, participate in interviews, even if we're just watching on the other side of the glass, to provide legal advice with regard to any issues that may arise. When the case ultimately comes into our office, we review it, decide what, if any, charges to file. and then off we go. We receive about 20,000 cases a year for review, misdemeanors and felonies, primarily misdemeanors. We look for whether or not there's sufficient evidence to proceed to trial. The burden of proof in a criminal case is beyond a reasonable doubt, which is the greatest burden of any case going through the judicial system. So we want to make sure that these cases have integrity. But what I tell the lawyers in my office, of which there are 53, it's not just filing charges, it's looking for the right outcome from the very beginning. And I know you have some questions you'd like to pose later about diversion, alternate sentences, and given Lynn's expertise in the area of mental health issues and substance abuse issues, I hope we can have a lot of discussion in that area, because I firmly believe that most offenders are either drug addicted, alcoholics, or have serious mental health issues that bring them under the purview of our law enforcement agencies. But basically, our job is to review the cases, decide what, if any, charges to bring, to interact with victims, to let them know what's happening, and then to provide them assistance through the criminal proceedings. In addition to 53 lawyers, we have 15 DA investigators who are sworn peace officers who help with the investigative process, both before and after the cases come into our office. We also have 15 victim advocates, and their job is to reach out to victims as soon as the case comes in, and then work with them and provide them with court support, as well as other assistance in getting financial assistance through the Victims Claim Bureau, which is a state agency. We also have 2 four-legged employees who are comfort dogs. Their job is to basically just be there for victims, help them sort of let go of some of the anxiety of coming to court, reliving their crimes, and they'll even accompany our clients or our victims into court when they testify. Their names are Miranda and Darla, and they're better behaved than the 2 that are in the room with me right now, who I warn you may well be acting out if this thing runs too long. But of the 20,000 cases we receive, I think we file around 60%. We always look for opportunities to divert them out of the system. And we're working with our law enforcement partners to even find diversion opportunities before they come into the system. Once they're in the system, I think 95% of the cases end up in plea bargains. It's very unusual for a case to go all the way through a jury trial. But if a case needs to, then we're prepared to take it. And we ask people like you all to come in and serve as jurors, sit in judgment, determine what the facts are, listen to what the law is, and decide whether or not the case has been proven beyond a reasonable doubt. In addition to our role in the courtroom, we do extensive outreach. Jim mentioned our elder protection unit. We're out meeting with seniors all the time, interacting with other agencies to provide wraparound services, not only to seniors, but to other people who may be in a vulnerable situation. We have a homeless outreach team that's out visiting a lot of these homeless encampments regularly to let them know that we have services available to them if they've ever been a victim of a crime. It could have been years ago. A lot of our homeless people have been victimized, forced onto the street, and never been able to get back into a stable situation. We can help them do that through a grant that we have through the state, and our homeless outreach team has been very effective. And then, of course, we have the family justice system, our Family Justice Center, which offers wraparound services to victims of family violence, sexual assault, elder abuse, and child abuse, offered free to anybody who lives in Sonoma County. Come on in. We have navigators trained to talk to the clients to find out what issue brought them to the center. And then we have advocates on site to help them deal with whether it's a restraining order, child custody order, they need some type of counseling, they might need a living situation, whatever it is, we're prepared to provide that assistance to them as well. So I think in a nutshell, that's what we do. We have a workers' comp fraud unit that I'd like to just highlight for people that are familiar with anybody who has a business. We're really looking out to make sure that everybody has adequate insurance so that employees are not being, they're being protected in the event that something happens in the workplace. We have another insurance fraud for auto theft. Most of our attorneys are trained to handle any kind of case. We do have specialized units in addition to elder protection in domestic violence, sexual assault, We have a narcotics unit and a DUI prosecution unit. DUIs are on the rise. Well, they're not on the rise. They're as busy as they've always been. Unfortunately, we have a lot of DUIs, a lot of vehicular homicides. So 130 people ready every day to do their level best to support members in the community who find themselves coming into the criminal justice system. And I will tell you, I'm sure there'll be questions tonight that will be maybe a little on the critical side. I get it. I'm leaving after 12 years of leadership in this office. I came in saying I was trying to put myself out of a job by doing such a good job that nobody would need a prosecutor going into court. I have failed in that effort, but I think I have succeeded in that we all realize we're in this all together. We need to work together to find smart solutions to reduce recidivism, to reduce violent crime, and make our community as safe as it can be. And I'm really proud to work with the Public Defender's Office. I have to say that because they get it. And as Lynn's going to explain to you, they've really stepped out in a number of extraordinary ways to provide for their clients. So while I represent the people, I also look for just results. And while the public defender's job is to represent their client, my office is mindful of the needs of the client as well when we seek a just result. So I think that was about, I don't know how many minutes, Jim, but that's all I got for you right now. It's been a long day.
Thank you. That's fine. Ms. Slater, you're up.
Thank you for having us. Before I begin with what the work of the public defender is now, I want to do a little bit of historical background to give some perspective. The right to court-appointed counsel is a fairly recent right relative to other constitutional rights. It wasn't until 1963 when a gentleman named Clarence Earl Gideon wrote a letter to the Supreme Court from his prison cell. He had been convicted of breaking and entering in Florida. He had asked for a court-appointed attorney and the court had denied him that right. So he wrote a letter on his own to the Supreme Court and made history in doing so. The court found in a unanimous decision with Justice Black, I believe, writing, that you were entitled to a court-appointed attorney and the right to counsel is a fundamental right under the 6th Amendment and under the 14th Amendment as incorporated to the states. So the right to counsel, if you're indigent, is a fairly newly recognized right. In California, the first public defender's office was actually opened in 1913 by California's first female attorney, Clara Foltz, who incidentally was also California's first female district attorney. So she did a lot of things in her career. Today, that history is reflected in statutory rules governing public defense in California. We are governed by Government Code Section 27706, which clearly delineates what we can and cannot do as public defenders. The vast majority of our practice is still criminal defense and juvenile delinquency defense. But really by statute and by practice, we represent anyone when their liberty is at stake. And that's not just jail. A person's liberty can be at stake where they fail to pay child support, where they're being conserved because of a mental health diagnosis, where they're subject to a probate conservatorship because of dementia, where they're confined to a state hospital because they're developmentally delayed, or they've been found not guilty by reason of insanity. So the breadth of our practice is a little bit larger than most people suspect. What it looks like today in Sonoma County is an office with 60 full-time employees, 32 attorneys, as well as an investigative staff, support staff, and new staff to us, post-conviction relief attorneys and a social worker. Those additional staff have been added because we're practicing a model of what we call now holistic defense. Instead of just defending the case, a particular set of facts, we're looking at the whole person. So to borrow a phrase which people have used before, instead of just pulling people out of the river, we're trying to figure out why they keep falling in the first place. Okay. So that means we're considering the whole person, and that model, which was actually started by the Bronx Defenders, they've done studies on that model, and we are actually part of the solution to public safety and the working relationship we have with our criminal justice partners. We have a unique confidential relationship with our clients and recognize that sometimes the justice system isn't the best place to deal with mental health issues, substance use disorders. So we have an opportunity as a holistic defender to connect people with services in that vital time where we have a confidential relationship, which can result in shortened pretrial detention times, shortened sentences, and reduced recidivism in the long run. So we have a rich history, but we've landed in a place where I think we can work collaboratively while still maintaining our core function of zealous representation.
Thank you. So I have two questions here. I'll ask both of you to respond. One of them is what criminal laws that are on the book should be modified or removed? And secondly, what new laws are needed? So you can answer either or both of those questions. We'll start with Ms. Ravage.
You know, I was talking to another elected DA the other day who became the elected DA back in the late 80s. And we were joking when he became DA, the penal code was about an inch thick. Now it's 2 volumes. The laws just keep getting passed time and again, and they're getting to the point where there's such inconsistency. It would be great for somebody to go through and weed them out. I don't know if it's ever going to happen. So I don't really know what to say about laws to take out other than it could use a good spring cleaning. But, you know, one point I'd like to make, which Lynn kind of touched upon, is everybody has a different view now of our role in the criminal justice system. It's not just prosecutors file cases, defense attorneys deny responsibility on behalf of their clients, and we go into fisticuffs. On both ends, we're looking for equitable outcomes. We're mindful about our victims' needs, but we're also mindful of the defendant's needs. And when Lynn uses the word collaborative, I think it's important for people to realize we have entire court systems set around collaborative efforts for veterans, for people with mental health issues, for people with substance abuse issues, that are all about giving them services and support instead of just imposing some sort of punitive consequences. So that's all been good. On the flip side, you know, what's gone that should be back? I'm very concerned about post-conviction relief, and Lynn touched on that. We are unraveling much of the work that was done years ago. I do believe that there are cases that should be unraveled. I applaud innocence projects that are happening throughout the country. I always tell people, if you got a case, bring it to me, we'll unwrap it, see if there's a problem. But there is so much post-conviction relief happening that it is weighing down both the DA's office and the public defender's office just because of the amount of litigation that's involved. And unfortunately, nobody's giving us money so that we can staff it properly to really serve the interests on either side. And as a result, you know, people are getting short shrift, and some people are being released that shouldn't. Victims are being denied their day in court. And so it's very difficult. Our legislature doesn't really understand what we do. There are very few lawyers in Sacramento. It would be great if people like Lynn would go to Sacramento and knock some heads together for others so that they would pass laws that would really make a difference. And the other thing I want to just say, because I know I'm talking too long, it's not just about what happens in the courthouse. And I'm going to use homelessness as an example. We can't fix those problems. Society has so many problems that don't belong in the criminal justice system. So if you really want to make a better world, back away from us and go talk to the people that closed all of the facilities that helped those that had mental health, substance abuse, homeless issues. go put money into those social services so that those people can regain their lives and be productive and give back to the community, which a lot of them would like to be able to do, as opposed to sitting in a jail cell waiting for their case to be resolved. So thanks.
Thank you. Ms. Slater, laws you'd like to see modified or removed or new laws put on the books?
Actually, my answer is not that dissimilar from Jill's. I'm sorry, Ms. Ravage's. I would like to see an end to what we call unfunded mandates. The legislature puts on the books, or the voters vote in initiatives, which are statutes or regulations that require other agencies, state or local governments, to perform certain actions. But there's no accompanying legislation to fund these. Let me give you an example. In 2018, new law on the books, mental health diversion. Completely applaud the law. It's a great program, great philosophy, great diversion program. But there was no money to fund it. The statute requires that we help establish the client has a qualifying mental health diagnosis, that was a substantial factor in the commission of the crime, and to set up a treatment plan that would address the criminogenic needs of the client. We're attorneys, we don't have the staff to do it. We had to rely upon our own behavioral health programs in the county to do it. They didn't have funding from it. Jill didn't necessarily have additional attorneys to review all of these petitions or to give meaning to a court to manage the program. And there are examples after examples like that of great legislation, well-meaning legislation, but that we have a challenge giving effect to because we don't have the personnel to do the work that the legislation requires. So that would be my soapbox for funding. And then my second comment was also going to align with Jill's, is that we have initiatives and legislation which take us so long to unravel because they're written by people who aren't in the trenches working on the system and don't know how the system operates. And occasionally we have legislation which is contradictory within each other. Mental health diversion and DUI diversion. I mean, there either has to be cleanup legislation or the system has to make, the issue has to make its way through the courts, the Supreme Court, and that takes time. And in the meantime, we're struggling to meet our mandates with no funding while we try to resolve perhaps inconsistent legislation.
Good, thank you. So another question is, what are your opinions about cash bail and the proposals for revising it? Start with Ms. Ravage.
Well, we actually have zero bail right now in Sonoma County. We've had it throughout the pandemic, so I guess we're in year 3 of it. I don't think people should be in prison because they can't afford to make bail if they don't pose a public safety risk. And I should point out, I was a defense attorney for 3 years, and I had clients that had to choose between bailing out, not being able to bail out, or pleading guilty so they can get back to work and pay the rent. And that shouldn't be a choice that they have to make. So I do think there should be bail in appropriate cases for public safety reasons. I think that bail should be denied in appropriate cases where the level of public safety is very high. But I also think we're lucky in Sonoma County because we have a lot of pretrial services available for low-level offenders. We went through, Lynn was part of this, as was her prior boss, Kathleen Posey. We sat down with lists of inmates and we reduced the jail population by about half, if not more, when the pandemic hit, so that those individuals were not trapped in jail, but could go home and shelter in place while we all tried to figure out what to do about COVID. They didn't reoffend while they were out. Most of them were, sheltered in place like the rest of us, just trying to stay safe. And we've continued that practice in terms of releasing individuals either on their promise to appear, with an ankle monitor where appropriate, with an alcohol sensor monitor where appropriate. There are a lot of ways that people can be out and about in the community doing good things that is more beneficial to all concerned than sitting in jail waiting for a trial. I am of the opinion, if you release somebody pre-trial, you watch their behavior, you watch their ability to return to court and follow whatever orders they're being given. And if they're successful in those endeavors, it greatly impacts the disposition of their case. Because at the end of the day, we want behavior modification. We want these people to stop committing whatever their offense is, and we want them to become productive members of the community. So I think that with the zero bail, we give them that opportunity. Thanks.
Thank you. Ms. Slater, cash bail.
I would concur with Jill's assessment here. Public defenders taken as a whole are not fans of cash bail because in the vast majority of circumstances, because we represent the indigent community, our clients cannot afford cash bail. And pretrial detention can have a devastating impact on a client's life, including the loss of job, loss of housing, for example, loss of HUD benefits, child custody, and it can really disproportionately impact certain communities along economic or racial or ethnic lines. So in part, that is why the court in what we call the Humphreys decision did rule that to condition a person's freedom on the ability to post bail is unconstitutional. So with that in mind, Sonoma County has developed a very robust pretrial supervision program so that individuals can be released from pretrial detention and really in the best case scenarios, show that they can not reoffend and at the same time address substance abuse issues, mental health issues, which may be mitigating factors in their case down the road.
Right. So we'll start with Ms. Slater asking a question about restitution. What could be, what goes on with restitution? And there's a restitution fund that some people have suggested could be working better. What are your opinions on the general subject of restitution?
Well, restitution is often a condition of a plea agreement that we would reach with the district attorney. Our role in restitution, if it's ordered by the court, is to make sure that the restitution amount is accurate based upon the facts of the case, and to make sure that if a condition of probation is made for restitution, that our client's able to pay it and not violated for not being able to pay it. In terms of the actual restitution fund and how it works, most of that is going to be within Jill's purview.
Sounds like Ms. Ravage is up.
Okay, well, so, you know, a lot of court fines and fees have been tossed out the window, both with regard to juveniles and adult offenders. They used to tack on all kinds of fines and fees and really ding people that were convicted of crimes in order to pay for things like building new courthouses and a whole host of other things. And the legislature's done away with that. But they've kept the restitution fine in place, as well as actual restitution. One is paying into a state fund. And what that state fund does is it provides assistance to victims in cases where the defendant doesn't have a means to pay, so that a victim can still get counseling, can still fix a broken window, can still do whatever was taken from them by virtue of the offense. So that's where that money goes into the state fund. In addition to that is restitution being owed directly to the victim, which the court may order, so that if Lynn broke my window, the judge may order as a condition of probation that she pay for the cost of repairing my window. So I really support restitution because there's no reason why the victim should carry the cost of the offender's wrongdoing. There are extensions where insurance companies get involved and they want to be reimbursed. Lawyers get involved. They want attorney's fees. You know, everybody wants a piece of the action. But in my mind, the most important thing is the victim be made whole. I mean, something happened to them that they had no part in causing. And I think that they have an absolute right to be made whole again, whether it's fixing a window or helping fix their emotions.
Good. Let's start with Ms. Ravage for this one. Could you explain qualified immunity and the controversy surrounding it?
No. Sorry. It's a judicially created immunity. And it happens more in the civil arena. I'm not going to even begin to have a discussion with you about the legal ramifications of qualified immunity. I can tell you that it touches criminal law, particularly in regard to police officer actions and actions by other government officials, and whether they enjoy certain protections by virtue of qualified immunity. I don't pretend to be an expert in the area. When we look at any type of immunity issues, it's usually in the context of, is there any justification for an act that has occurred? And I'm going to use a police officer as an example. If a police officer uses force, we have to look at whether or not that was justifiable under the circumstances. And there's a lot of discussion about qualified immunity in that regard, because police officers are given that opportunity to use force in the right conditions. So we have what are called jury instructions that lay out what the particular justifications are that juries have to find in determining whether or not members of law enforcement are responsible for crimes. That's really all I want to say in regard to the impact of qualified immunity. I know you're going to ask me about Andy Lopez. I expect to continue to be asked about that tragedy even after I retire. I imagine this question is in that context. And so what I will offer is this: the law has changed with regard to qualified immunity for law enforcement officers from the time that Andy Lopez was killed to today. And the justification for the use of force is different under the law today than it was back then. And I think an example of that change can be found in the fact that we took a deputy sheriff to trial and charged him with manslaughter in connection with the death of an individual who was driving what they believed to be a stolen car. Jury found he wasn't guilty, but we felt that under the law, with the changes that existed, there was sufficient evidence to bring him to trial. It's a constantly evolving area of the law, and it really, I think, is more impactful in the civil arena when people bring civil claims against law enforcement, as opposed to in the criminal arena when we bring criminal cases. So.
Ms. Slater, do you have any comments on the concept of qualified immunity?
No, in 30 years of me being in the office, we've never had a case involving qualified immunity, which makes sense because most of those individuals would not qualify for our services.
Right. So continuing on with regard to the issue of law enforcement, Ms. Ravage, could you walk us through the process that happens in your office when a peace officer is involved in a dramatic use of force incident that appears in the newspaper, and you have he said, she said, multiple perspectives reported in the press. And this obviously falls in your lap very quickly. What does your office do in circumstances like that?
Well, the first thing we do is we remind ourselves that what you read in the newspaper is not always factually accurate. And what you see on Facebook or in social media is not always factually accurate either. So we take a pause and we take a look at what we really have. And let me point out that members of law enforcement are human beings, and we prosecute them more frequently than you would like to know for things as minor as driving on a suspended license, driving while intoxicated, domestic violence, even theft or embezzlement. They're like every other human being where they make bad choices. And if they do, we will hold them accountable. In those cases where an individual is injured because of a use of force, which I think is where you're going with your questions, we take a look at all the facts and circumstances that are known to us and make sure that we do a thorough review. In my office, if there's an officer involved fatality, our homicide team goes out to the scene. We are there while the investigation is occurring. We witness the interviews. When the investigation is completed, which is done by an agency other than the involved agency, we review the investigation and determine whether or not criminal charges should be brought. I issue a report. If there are no criminal charges to be brought, those reports are up on our website. Anybody who wants to read them is free to see them. If we decide criminal charges, sorry, I've got a dog here. If we decide criminal charges should be brought, then we file a case. And that was what we did with Charlie Blount. We filed a manslaughter case, took it all the way through jury trial. We have another case that I think is starting right now against a man named Lance Novello, who was a sergeant in Petaluma, and he is charged with using excessive force against a woman down there and committing a battery upon her. So, nobody's above the law. And everybody knows that I'm willing to prosecute police officers if indeed they have broken the law. And I will tell you, I know you want to talk about body-worn cameras. What a great tool for all.
My next question.
So I'll just go ahead and jump in there and then I'll shut up so Lynn can say a few things. But if we had had body-worn cameras years ago, I think a lot of the cases that have caused the public to be suspicious about excessive force on the part of law enforcement might have been resolved. Because what we found, since those body-worn cameras are now recording interactions, if somebody comes into an agency to complain, they play the video for them so that they can see exactly what the interaction was. At the same time, if an officer acts inappropriately, it's on the video and the officer cannot deny it. And so I think it's a really powerful tool that can both exculpate and inculpate a member of law enforcement.
Thank you. Ms. Slater, do you have any observations on the issue of body-worn cameras and their utility?
I would concur with Jill that body-worn cameras have been caused a tremendous shift in the system and the way that we investigate cases and resolve cases. I think there's been no more significant change in our ability to resolve cases than to have the body-worn cameras, because we have it on film. Now, having said that, not all cases are on body-worn camera, right? You only are going to get a body-worn camera where there is an officer interacting with the suspect. But, if some of the recent events that have been reported by the Press Democrat, for example, major cases, the incident themselves are not on body-worn camera, but you may have the encounter with the suspect on body-worn camera. So it doesn't give you the entire picture, but it gives you enough that sometimes you can resolve a case or say to the district attorney, I know what the report says, but take a look at this.
So in addition to body-worn cameras, we see stories in the press around January 6th issues in the events in Washington of thousands of cell phone videos being taken. How useful do you find cell phone videos by either just people walking by or by people involved in some interaction themselves? How do you sort through all those stuff? To start with Ms. Slater.
Well, if people are bringing us cell phone videos, it's typically because they believe it contains some exculpatory information or information that's going to help our client. People aren't typically, although they occasionally do, bring us videos that really would be more benefit to Ms. Ravage's office. So in the event of the exculpatory cell phone video, we certainly have ethical duties we need to comply with, confidentiality duties we need to comply with before we can take that video over, investigate it, and then use it at trial. It is occasionally useful, but not as often as you may think.
Ms. Ravage?
So the cell phone is an amazing piece of evidence because it's not just the video. And I have had cases I've dismissed after I've watched videos. And I've also had cases that have been bolstered by watching those videos, but they also track us. We know where everybody is. by your cell phone. In case anybody is wondering, you have no privacy anymore. So in fact, for you, Jim, I don't know where you are. I think you're in the East Bay, but I can find out where you've been all day by pinging your phone, right? You can ping phones. You can find out when it touched a particular cell phone tower. We just did a case, I don't think Lynn's office was involved, where a woman was picked up in San Francisco by what she thought was an Uber driver. She was driven over the bridge all the way up here to the Sonoma area, raped, beaten, thrown out of the car, et cetera, et cetera. And we were able to track it through cell phone tower dumps. So we knew exactly where they went. And that had nothing to do with anybody taking a video. So the cell phones they're very powerful tools, not only to show the commission of a crime, but also to exculpate. Because if Jim Masters came to me and said, Jill, I was nowhere near that thing that you say that I did, and here's my phone, and we go into your phone and see where you were and what you were doing. In fact, yeah, unless of course we say, well, Jim, somebody else was using the phone at the time and we think you did it. But I don't know that that necessarily happens, but they're very powerful. And I always tell people, be careful what you put on those phones because people can access it. The same with social media. You should always be careful because you can never undo what gets put up there.
Just to give you some measure of protection, for law enforcement to get into your cell phone, it still requires a warrant or an exception to a warrant. So if you consent, they can still access that. But Jill, I don't think is running around seizing evidence from cell phones without a warrant or seizing your tracking data without a warrant.
No. I'm just saying it's there, it's possible. Listen, when I went into the business 35 years ago, a fingerprint was an amazing piece of evidence. If you had a partial fingerprint, you had the best case in the world. Nowadays, juries don't accept that. They want DNA. They want body-worn camera video. They want cell phone dumps. You name it, they want it because most jurors don't even believe it when a witness says, that's the person, I'm sure I saw that person. They're like, no, you don't know who that person is. We want DNA. So it's a very different world in the courtroom now. And CSI evidence is really what jurors are looking for.
What a great segue. A few years ago, there was great controversy about law enforcement processing rape kits and acquiring and analyzing physical evidence in rape cases. How's Sonoma County doing in that area?
We're doing great. In fact, we were part of a pilot project that started, I'm sorry, I cannot remember the name of the project, but I can get back to you on it if anybody wants it. Years ago, we looked at it and said, wait a minute, if we get any rape cases sitting, or rape kits sitting on shelves, no. We're part of a pilot project so that all those kits are going to DOJ for purposes of analysis in the event that something comes up. I mean, when people choose not to go forward with a prosecution, we're not going to push a case, but we're also not going to leave a case sitting on a shelf somewhere and forget about it. So Sonoma is very forward thinking in that regard.
So Sonoma County is provided for legal growing of cannabis. What do you, apart from the regulatory issues and the water issues that have been controversies described in the press, what's the law enforcement perspective on the new cannabis ordinance and its impact on that industry?
Is that why we put the cat up on one of the little pictures there? See if
no, that's Judy Coleman's cat. She's one of our Zoom operators.
I'm just joking. Maybe she was enjoying some cannabis. I wasn't sure.
No, I think she's trying to get the Spanish interpretation slide back up.
I'm just kidding, but everybody accepts that marijuana is legal now. The problem that we're encountering is in the form of the illegal grows. The people that are trying to do it legally are really pissed off because they're getting taxed and they're trying to jump through hoops to get permitted, while the people that are doing it illegally are selling it on the black market and still making enormous profits. And we're looking at that from a law enforcement perspective. I'm always concerned about it from an environmental perspective because people growing marijuana oftentimes are using very strong chemicals that are going into our groundwater. They're diverting stream beds. They're changing the terrain so that the water runoff is impacted. All kinds of environmental problems that we need to address. With regard to personal consumption, all I ask is if you're going to get stoned, don't get behind the wheel, because we are prosecuting people for driving under the influence of cannabis. And cannabis combined with alcohol is a really powerful intoxicant, and people can cause a lot of danger when they're behind the wheel. But otherwise, law enforcement, you can have a U-Haul truck full of marijuana, and at best, it is a misdemeanor crime. We're not prosecuting it whatsoever, unless Lynn knows of cases that I don't.
Ms. Slater, any comment on the cannabis industry or its issues?
Well, not unlike some of the prior questions, Jill prosecutes a lot of areas, in a lot of areas or types of cases that we will never see as indigent defenders, because those individuals have the ability to hire counsel on their own. Even in the height of marijuana prosecution, perhaps more than a decade ago now, we often would not have the major growers. Our office would typically represent the trimmers who were transient and would go from grow to grow. So the only impact on our practice now is really addressing some post-conviction relief. There was a large cleanup of those convictions done collaboratively with Ms. Ravage's office a couple of years ago, but we're still doing a little cleanup for people who are trying to get those convictions expunged or dismissed.
So there's been stories in the press and research about racial disparities in law enforcement. I have a general question and a specific question. The general question is, how's Sonoma County doing with regard to racial disparities in law enforcement? And I'll start with Ms. Slater.
Well, I'm actually going to punt this to Ms. Ravage first, because no, here's my reasoning, Jill, is that law enforcement really starts on the street. And it's not until a complaint is filed that we are appointed by the court. We're seeing the back end of it. So I'm going to defer to Ms. Ravage, at least for the first part.
Okay, well, listen, when you talk about racial disparity in law enforcement, let's start with the people wearing the uniforms. Sonoma County is white and male. Those are the people wearing uniforms. And let's talk about women in law enforcement. When I go to meetings with all the chiefs throughout the county, I'm the only woman in the room. And this has been going on for over a decade. We had a female chief in Healdsburg when I first came in, and we had a female chief of SMART, which was a department of one. So let's think about women in law enforcement, and then let's think about people of color in law enforcement too. Because when you encounter somebody wearing a uniform and they look a little bit more like you, maybe the interaction is a little better than if you're just encountering somebody who you don't see in your ordinary life, who maybe doesn't understand the life that you lead. So I think the disparity in law enforcement is, it's a problem in Sonoma County. With regard to treatment of people of color, I don't see it. To be honest, every time I say that, people say you're not opening your eyes. You don't know what's happening there. I will acknowledge, however, when Andy Lopez was killed, there was an incredible awakening in Sonoma County around the disenfranchisement of the Latino community. And I made my best effort to reach out to the Latino community after Andy Lopez was killed to try and say, tell us what we can do so we can communicate better. And I think members of law enforcement joined in that effort. We've had changes since with the implementation of IOLERO. We still have a long way to go though. I mean, if a community feels that it's not being protected because of the color of its skin or the zip code, then Sonoma County has a real problem. And we have a sheriff's race coming up, and that'll be a good question for you all to pose to the sheriff candidates. We have a new police chief coming into Santa Rosa, and those of you participating in that should be reaching out as well. I've tried to build diversity in my office. I think I've been pretty effective. I'm stuck with whoever the candidates are. I mean, you know, you put a recruitment out and whoever applies. And if you don't have a diverse group of applicants, there's nothing you can do about it. But I do think law enforcement can do a better job of recruiting people with more diverse backgrounds, and that can make a difference on the street.
Ms. Slater, do you have anything to add on that topic?
Sure. What we're able to discern from what happens on the street is what we can capture in a body-worn camera, or what our clients can tell us in an interview, or what our witnesses are able to share with us. And we still have many of our clients telling us that they feel that there are racial or economic or ethnic or other disparities taking place on the street. When we do have evidence of that, for example, on body-worn camera, that is something that we're going to share with the district attorney's office and with the particular law enforcement agency. I saw a disturbing one yesterday, which made disparity of the individual's IQ, calling the individuals a term that we would not be using today. That's going to be shared with law enforcement and with Ms. Ravage's office. So it is still out there. And I think the largest disparity our clients note is if they're sitting in front of a jury. If we have a Black male client in front of a jury, that client's going to turn around and look at the panel of 40 individuals behind him and most likely see 40 or 35 white individuals who tend to be toward the older range. So we look at it at the beginning. I think it's noticeable in the process, and it's noticed at the end, certainly by our clients. We do have some remediation now. We have one of the new unfunded mandates is the Racial Justice Act, which gives us the ability to go back and look at convictions where we think they may have been based all or in part on racial disparities or ethnic disparities. So we're seeking out an attorney to do that. Again, that's going to have to be grant funded because we don't have the money to do that. So we're still seeing it. We're still getting reports of it. And when we see it, we're trying to take action as we can.
I have two closing questions. One is you're mentioning on the street, Ms. Slater, is a good segue. We've been reading in the newspaper and in the press releases from the police department about sideshows. Is there any way to move these over to the Sonoma Raceway or to some abandoned cornfield someplace to get them off the street so they don't create hazards for other people, but to still provide an opportunity for people to do strange and dangerous things like climbing a mountain or going off a ski lift or diving under the ocean surface or any of the other things people do that are dangerous and high risk, but that seem to involve a particular ethnic group and create a public controversy around it. So what do we do about sideshows? Ms. Ravage, we can start with you.
Thanks a lot. Well, you know, the police are trying to do what they can do. They're trying not to interrupt them because they can get volatile. We had a homicide in the middle of a sideshow. They put those giant box dots up, so it's more difficult to use some of the intersections. I think that the city leaders are trying to work with community members to establish some sort of rules of the road, so to speak. But you know, the problem with sideshows is you attract a large audience. And so if you say, let's all go to the Speedway and have a sideshow, nobody's going to go to the Speedway. They want to hang around near the taqueria or their backyard or whatever. I mean, it's a big social event. And for some people, there is no criminal aspect to it. It's just part of their culture. So I don't know what you do unless you reach kind of a détente where there's an understanding that some of this behavior can occur, but it's got to occur in a safe setting. It's difficult.
Ms. Slater?
If I had the answer to that or to homeless or any of these other issues, I'd have a different job.
So my final question is, we've heard a lot of issues where you are in agreement with each other. Can you identify at least one or two issues where there are differences of opinion about what is being done or should be done? We'll start with Ms. Slater.
Well, I think where you continue to see the kind of traditional disparity is in the courtroom. I think it's safe to say all of us want a healthy, safe community where people are free to be themselves, celebrate their culture, their families, etc. But it's how you get there. And it's on those really difficult cases where there are factual disputes that sometimes do have to go to trial. So we can disagree in fundamental ways about the facts, about the evidence, and sometimes how to reach just conclusions in those situations, even though we all want the same thing in the end. It's the how do you get there that results in the disagreement. With some of the second, I would say with some of the new legislation, which really pushes back, as Ms. Ravage mentioned, it's not just undoing convictions. For example, we have sexual offender retiering, which for some individuals will get them off the sexual offender registry and get them back to a place where they can be fully employed, live what they want to, etc. if we show that they are at low risk of reoffense and that the sexual offender registry is no longer adding to the community safety. You know, we're disagreeing on some of those because of the nature of the underlying convictions. So even though we are working collaboratively on some of this new legislation and remediation, there are some situations where we're still going to go head to head because we have a different interpretation of the facts or the evidence.
Thank you, Ms. Ravage.
So I think that's a good point. I mean, I agree in the tiering. It used to be a life crime, lifetime registration requirement if you were convicted of certain sex offenders. I agree that it should be tiered based upon the severity of the underlying offense. People shouldn't be labeled for life. But I feel very strongly. I mean, I'm going back to a parole hearing for a man the judge told was going to prison for 111 years, and he hasn't been there for very long, and he's already coming up for parole for the second time. Things like that are really difficult. But I agree with Lynn. I think philosophically, we agree that we want our community to be safe. We want the members of our community to be healthy. We want the general welfare of our community to be good and positive. I think that the public defender focuses on the individual, which they should. It's their client. Whereas the district attorney's office is maybe viewing things with a wider lens and needs to be reminded from time to time to focus on the individual and remember that the individual can impact the bigger picture. And conversely, that the defense needs sometimes to remember the impact on the victim. While they represent an individual, the harm that this individual has caused can be pretty substantial. And I've had a lot of conversations with defense attorneys to remind them that it's not just about their client, it's about what their client did and the impact that it's had. But at the end of the day, like I said in the very beginning, we are a very collaborative county. Some counties, the PD and the DA don't even talk to each other. We philosophically believe that justice partners need to communicate with each other to reach a just result. And that extends to probation, to the courts. We all meet regularly to see how we can move things more efficiently. And even though we may disagree on a particular case or a particular sentence, we act with respect toward one another and with a common goal, which is to seek justice for whomever our client is, and at the end of the day, to have a healthy community. So I've been proud to be part of this community. And as I said, to serve as district attorney for the last 12 years. And I hope that as things unfold, it will continue along this same path.
What the question I should have asked you, or one of the participants should have asked you that we didn't ask you?
Well, I think you should have asked me, why did I stick around so long? It's a tough job. My goodness, it's really a tough job. But No, I mean, I think people always ask me, what's your legacy going to be? And I always say, I don't really deal in legacies, but what I will tell this group is my legacy will be the work that the district attorney's office does in years to come. I made it my business to build an office of dedicated professionals who believed in the pursuit of justice and understood that we did the right thing for the right reasons at the right time. And hopefully that will bear out in years to come.
Thank you. Ms. Slater, what question should I have asked you, but I forgot to ask you?
Well, I'm actually going to tell you what question I'm really happy you didn't ask me, because it's a question that I usually get, sometimes at the cocktail party, sometimes on forums, and that is, how do you do what you do? How do you represent people you know are guilty? And I think the fact that I didn't get that question is a testament to your membership's fundamental understanding of the work that we do. I always say that we don't have to believe in our clients' innocence, but we do believe in our clients' humanity and the ability of everyone to make changes, the ability of everyone to reform and return to the community where they may have previously offended. So that's our message, I think.
Thank you. Thank you both. I want to thank District Attorney Joe Ravage and Lynn Slater, Chief Deputy Public Defender, for their remarks tonight. I want to point out that if you like this kind of educational forum, join the Sonoma County League of Women Voters. Go up to our website and you can join right on the spot. I also want to mention that the State League of Women Voters has a 4-page position on criminal justice on the State League of Women Voters website, which provides guidance for all of the local leagues of women voters. And I want to, in addition to thanking our speakers, thanking our team behind the scenes, Ricardo Ibarra, our translator, interpreter, Lynn Dooley and Judy Coleman are behind the scenes Zoom host. Debbie McKay is our secretary, is back there. Donna Roper, our president, who you heard from. Leona Judson has been sorting the questions in the background. And with that, I want to say good night to everybody. We really appreciate it, your attendance and participation in this League of Women Voters of Sonoma County educational event. Thank you all and good night.